Hello and welcome to TVC News. This hour we are monitoring developments at the Federal High Court in Abuja, where 109 foreign nationals have pleaded not guilty to 6-count charges of high-level cybercrimes, hacking and activities that threaten national security. The defendants were arraigned before Justice Ekirite Akpan. Senior reporter Celestina Iria has details.
The Nigerian police force had on 3rd November arrested a suspect in an operation that was conducted during a raid on a building at Neskash and Kari area of Jabi, Abuja. The defendants were reportedly using computers and other sophisticated devices to facilitate criminal activities. The operation, which was led by the Assistant Inspector General of Police for Zone 7 Headquarters, Abuja, AIG Benedict Ikwe, comprised officers of the Nigerian Police Force Zone 7 Command Abuja and National Cybercrime Center. Delivering the ruling, Justice Ekirite Akpan granted bail to the 109 defendants in the sum of 1 billion naira and 5 sureties. The 5 sureties must each have property worth 200 million naira each located in Abuja. The defendants are to deposit their passports with the court. The sureties are to deposit 2 passport photographs with the court. The sureties are also to swear to an affidavit of means and submit the documents of the property with the registrar of the court.
The relations here, I think, is fair, and we are ready to meet up the condition of the bail so that they can come out, so that we can profile them and ensure that they will take proper brief to conduct the trial. It's a fair bail condition.
The defendants are to be remanded in Kuje and Suleja Correctional Center pending the perfection of their bail conditions. The court adjourned to 27 February 2025 for trial. Celestina Iria, TVC News, Abuja.
Well, staying with judicial matters, the arraignment of the former governor of Kogi State, Yahaya Bello, at the Federal High Court, Abuja, has been stalled due to the absence of his lawyers in court. The EFCC brought the former governor for arraignment on a 19-count charge of money laundering to the tune of 80 billion naira. Celestina Iria reports.
At today's proceedings, counsel to the EFCC, Kemi Pinero, moved an application for the charge to be read to the defendant and his plea to be taken. But Yahaya Bello, who addressed the court himself, told Justice Emeka Waite that he was notified of the arraignment in the late hours of 28 November. As such, he could not inform his lawyers. In a short ruling, Justice Waite held that it would be in the interest of justice for the defendant's counsel to be present. A warrant for his arrest cannot be sacrificed on the altar of breach of fair hearing. Also, that counsel to Mr. Bello should be put on notice. The court adjourned to 13th December for arraignment and ordered that the defendant be remanded in the custody of the EFCC. Mr. Bello is accused of money laundering, abuse of office, and criminal breach of trust during his time as governor. Justice Emeka Waite had adjourned to January 25, 2025 for ruling on 2 applications filed by the EFCC, one seeking to try Mr. Bello in absentia and the other seeking to enter a plea of not guilty on his behalf. However, due to the recent development of the case and Mr. Bello being in the custody of the EFCC, those applications have never taken by event. Celestina Iria, TVC News, Abuja.
Here in Lagos State, the Court of Appeal has discharged and acquitted the medical director of Optimal Cancer Care Foundation, Dr. Olufemi Olaleye, following a successful appeal challenging his conviction and life sentence for defilement and sexual assault of a minor. Kemi Folade has details.
It was a unanimous decision of the Court of Appeal comprising of Justice Jimmy Dada, who delivered the lead judgment, as well as Justices Abdul Dogo and Mohammed Abubakar, in determining all the 5 grounds of appeal in the favor of the appellant. The court accused Mrs. Olaleye, the first prosecution witness, of scheming to take over her husband's assets and custody of the children in a calculated manner. She was described as a witness whose evidence should have been treated with considerable caution. The court added that such evidence and that of the alleged survivor needs corroboration to establish the elements of penetration and lack of consent before the sexual offences could stand. The appellate court also faulted the evidence of the child forensic witness, describing it as hearsay and the quote, worthless evidence of the medical doctor who examined the alleged victim. It queried why the prosecution failed to present material witnesses such as the divisional police officer in whose office the appellant had made the alleged confession and a relative of Mrs. Olale who heard the alleged confession. The appellate court said there was material contradictions in the evidence gathered by the prosecution which shouldn't have been relied on by the lower court. In the words of the appellate justices, the trial judge Raman Oshodi of the Lagos State Sexual and Special Offences Court descended in the arena and interfered in the proceedings to bridge what it called the yawning gaps in the prosecution's case. The lower court had held that the Lagos State government had proved the charge against the defendant and that the evidence against him was compelling, saying at the time that Dr. Olale's confessional statements before his former counsel, Olale Koburuji, and the DPO at the Anthony Police Station in Lagos proved that he committed the offences. But in Friday's judgment, the Court of Appeal overruled that position, saying instead that the trial within trial ought to have been conducted at the lower court to verify the voluntariness of the appellant's confessional statements while in police custody, which he said he had made under duress after he had been detained for 6 days. This, the court said, was in the spirit of Section 36, subsection 6 of the 1999 Constitution as amended, which dictates that fair hearing also be afforded to the defendant during a criminal trial. Kemi Foladeyemo, TVC News, Lagos.